The broadcast is now starting. All attendees are in listen-only mode.
Happy Thursday, everyone. Welcome to today's webinar on coronavirus in the workplace, practical guidance for employers. I'm Anna Hobson, the marketing manager at hrsimple.com, and I will be moderating today. Today's webinar will be presented by Fiona and Mark from Shaw Rosenthal. The presentation will be about 90 minutes long. If you have questions, please submit them into the chat box, and Mark and Fiona will answer as many as they can at the end of the webinar. If you need to view our webinar again, you can go to youtube.com/HRSimple. Now we will take some time to learn a little more about our presenters. Mark has extensive experience defending employers with respect to age, race, gender, and disability. His practice requires him to routinely appear before state and local administrative agencies, as well as federal and state courts throughout the country. In the traditional labor law area, Mark guides employers through representation and unfair labor practice cases before the NLRB and advances employer interests in collective bargaining and arbitration proceedings. Fiona defends employers in the areas of employment discrimination, wrongful discharge, and wage and hour regulation, both in court and before federal and state agencies. She also provides advice to managers and human resources on a wide variety of matters and conducts training on harassment, reasonable accommodations, and other issues for both supervisors and employees. Fiona is also author of HR Simple's Maryland Human Resources Manual. So at this time, I will pass it over to Fiona and Mark, and we can get started.
Anna, thank you very much.
Welcome.
This is Mark Swerdlin, here with my partner Fiona Ong, as Anna said, and we're happy to present today on coronavirus in the workplace and hopefully give everybody listening some guidance that they can use to deal with this very difficult and serious situation. As everybody likely knows, President Trump has declared the COVID-19 outbreak to be a national emergency. Governors in many states, including Maryland, where Fiona and I happen to be, have declared state emergencies. The CDC had recommended not that long ago that no gatherings of more than 50 people occur over the next couple of months. President Trump actually just the other day went even further and said that the limitation should be to groups of no more than 10 people. He also, in making that pronouncement, urged that older people should stay home, that we should all stay away from bars, restaurants, and avoid discretionary travel. He had suggested closing schools and canceling social visits, even in our homes. Since that time, bars, restaurants, and gyms have closed in many jurisdictions. Shopping malls, entertainment complexes, casinos also are among the types of businesses that have closed just in the past couple of days. Also in many jurisdictions, schools are closed, and the expectation is that most, if not all, school districts will complete the school year online. We're all supposed to refrain from travel. At this point, coronavirus has been reported in all 50 states, and the numbers of infections continue to spiral upwards. We know this is an incredibly fast-moving and volatile situation, and frankly, employers' legal obligations are shifting really from moment to moment. Just this past weekend, Saturday morning at 1 a.m., the House passed the Families First Coronavirus Response Act. The House thereafter made some technical amendments to the bill, which were actually somewhat significant. And yesterday, the Senate passed the bill, and President Trump has signed it. So we now have this new legislation, and Fiona is going to take you through some of the key elements in a moment. You're seeing now the famous and maybe dreaded disclaimer slide. We're lawyers, so we've got to put that up there. It's kind of in our contracts. So you can read it if you're really interested, but it boils down to the fact that we're not giving you legal advice. And if you have questions that require legal advice for your particular company, you should contact your lawyer, whoever that happens to be. If we've got some time at the end, we will try to take some questions, and we'll see how that goes. Before we jump into the new legislation, which Fiona is going to start us with, just want to remind everybody that we all have, as employers, a tremendous number of obligations relating to various employment still exist, even with this. Many of them have the new we're talking about. So, of course, we've got obligations under OSHA and state OSHA acts to provide a safe workplace. That's going to come up in connection with what happens if you've got an employee at work that may be suffering from coronavirus or exhibiting symptoms. There are laws under the ADA, HIPAA, and state laws that deal with medical examinations and inquiries. We'll be talking about the fact that the EEOC actually just issued some new guidance on whether employers can now take temperatures of their employees, which heretofore had been something that would have been considered a medical examination and disallowed. There are various leave and benefit laws, both from the federal and state level, that we've got to be concerned about, of course, and also look at how the new law is going to interact with that. So we're pretty much familiar with FEMLA and safe and sick leave laws that are being passed in more states and localities, seemingly on a week-by-week basis. We'll talk about that, as well as some state unemployment insurance laws, which become very important as a number of companies institute layoffs or put employees on furlough. We also have wage payment laws, both from a federal and state perspective, that are important to consider when we talk about things like teleworking, and we'll be discussing how a greater segment of the work population is going to a telework mode than ever existed previously. You need to be concerned about our usual non-discrimination laws, Title VII, ADA. There's a lot of talk about the coronavirus being that individuals 60 and older may be more susceptible, as well as people with compromised immune systems. So we'll talk about age issues related to that. There are a number of you in the audience that are likely unionized, and you've got bargaining relationships with the unions that represent a portion of your workforce. There are obligations that will kick in there, but also, even if you do not have a union, there is an aspect of the National Labor Relations Act which can apply to non-unionized employers and certain activity that employees engage in called protected concerted activity. So we'll talk about that to make sure that you non-unionized employers are also aware of the pitfalls that could exist if you take some action that would be arguably violative of the National Labor Relations Act. And finally, in this discussion about other employment and labor laws that we need to be mindful of, there are numbers of employment laws that deal with loss of employment, like WARN, and there are certainly state laws as well. We'll probably focus on the Federal WARN Act and COBRA. With that said, Fiona, I'm going to turn it over to her, and she's going to start talking about an important aspect of the Families First Coronavirus Response Act.
Well, there is an old Chinese proverb that says, may you live in interesting times, and I would say that, boy, these are the most interesting times I've ever been through. And I'm chatting with a friend of mine who's an OBGYN, and she's expecting a baby boom in about 9 months because, gosh, everyone's home with nothing else to do. So they've already named this next generation. They're going to be called the Coronials. So hopefully that was a bit of an amusing moment for you in this very serious time.
Fiona, we're not going to have a new baby in my household, but we're watching lots of Netflix.
Well, let's turn to the newest and biggest development here, the Families First Coronavirus Response Act. As originally drafted, this bill would have made sweeping and permanent changes to the employment relationships, such as the implementation of paid sick leave for all workers for any reason, but this has been pared back, and the version that has now come into law is targeted only at the current COVID-19 outbreak. The bill does the following things, which we're going to discuss in detail in a moment, but it creates a new paid sick leave mandate for COVID-19 related reasons. It expands the Family and Medical Leave Act to include a COVID-related reason and also imposes another new paid leave mandate. It expands the eligibility for unemployment benefits, or encourages that expansion for COVID-19 related reasons, and uses a payroll tax credit to fund the paid leave mandates. So the paid leave provisions are going to be limited to employers with fewer than 500 employees. So larger employers are not affected, and Many people have asked, why this limitation? I heard Senator Bill Cassidy say that if most of those larger employers already provide some form of paid leave to their employees, it can likely be used during the current situation. So one of the major questions is, when does it take effect? It takes effect no later than 15 days, according to the language in the Act, which is April 2nd. And the Secretary of Labor has to issue some regulations because there are a lot of things that are just very unclear about this particular Act. I was on a conference call this morning with Senators Cardin and Van Hollen from Maryland, and I asked about whether or not this effective date is going to be sooner than April 2nd and when those regulations might be issued. And they said they don't have any information about that other than to say that the Secretary has been informed of the urgency. We don't anticipate that it's going to be able to be effective prior to April 2nd, just given that, these regulations usually take months and months and months, if not longer, to issue. So the fact that they're supposed to come out within 15 days is pretty darn quick. So stay tuned. We'll certainly be keeping people up to date with regard to those regulations. So let's start off with the Emergency Paid Sick Leave Act. Like the FMLA portion of the Act, as I said, this paid sick leave portion applies only to employers with fewer than 500 employees. And employees are defined by the Fair Labor Standards Act. So that count is going to include both full-time and part-time employees and temporary and seasonal employees, but not interns or volunteers. And it is all the employees within a company, just not just the people at a single location. In addition, if you have affiliated companies like sister entities who are separately incorporated or parent subsidiaries, I think a single employer analysis is going to apply in order to determine if the operations and management are so interrelated that the employees are combined for that 500 employee count. But just keep in mind that if you do end up being a single employer, those affiliated companies are going to take on the liabilities of each other for violations under the FLSA, the Fair Labor Standards Act, and other laws. Under both the paid sick leave and the FMLA expansion, the Secretary of Labor can issue regulations that are going to exempt certain healthcare providers and emergency responders from receiving these new leave rights, and employers with fewer than 50 employees will be exempted if the leave rights, quote, would jeopardize the viability of the business as a going concern, unquote, whatever that means. And that's what we're going to have to wait for those regulations to see.
So Fiona, if I could ask you a question right at the get-go. I'm a small business with 10 employees. I think this thing is going to devastate me. Can I just say this is going to jeopardize the viability of my business? I'm not going to comply.
I think we're really going to have to wait and see. They're talking about applying for a waiver from the Secretary of Labor. So the Secretary of Labor presumably is going to have to come up with some sort of protocol and issue that within the next 2 weeks in order for people to be exempt from that particular obligation. And so we're just going to have to wait and see.
So we could have thousands or tens of thousands of small businesses around the country applying at the same time for a waiver?
I know. Doesn't that sound scary? I'm not sure how that's going to work, and I'm so sorry. But of course, we'll keep you up to speed as soon as we get any further information. So the Emergency Paid Sick Leave Act provides 10 days of paid leave. As originally passed, the Act weeks, and that's we're now talking about 10 paid days. Full-time employees are going to receive 80 hours of paid sick leave. Part-time employees are going to receive a prorated amount of paid sick leave based on the hours that they work on average during a 2-week period. And if the part-time employee works a varying schedule, those hours are going to be calculated by determining the average number of hours that the employee was scheduled to work over the prior 6-month period, including any leave that they took. If the employee has not worked during that period, during that entire period, then the hours are calculated based on the reasonable expectation that's higher of the average number of hours per day that he or she would have normally been scheduled to work. The Secretary of Labor is going to issue guidelines to assist in that calculation within that 15-day period that I've been talking about. And paid sick leave is going to be compensated at the greater of the employee's regular rate, as calculated under the Fair Labor Standards Act, the federal minimum wage rate, or any applicable state or local minimum wage rate. Now, really, that's going to translate to the employees' regular rate, because hopefully nobody is violating those minimum wage laws by paying their employees below the minimum wage. If the paid sick leave is used to care for a family member, or because of a school closure or lack of child care, and those are some reasons we're going to talk about in a moment, then the rate of compensation is 2/3 of the regular rate. There are going to be caps to the dollar value of the leave that has to be provided. So if an employee uses paid sick leave for their own personal reasons, the cap is going to be $511 per day for a total of $5,110. If the cap is used to care for somebody else, if the leave is used to care for somebody else, the cap is going to be $200 per day and a total of $2,000. So those are the new caps that are going to be used to align with the paid sick leave tax credits that are going to be used to fund the paid sick leave mandates. The Act also contains a provision specific to employers that are part of a multi-employer collective bargaining agreement. And those employers comply with the Act by contributing to a multi-employer fund, plan, or program at the required statutory rate, as long as employees can receive pay for the specified reasons from this arrangement. And it occurs to me that we actually do not have a slide that covers the specific reasons that can be used for this leave, and my apologies. So the reasons that this leave can be used are if the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19, they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. And so under those three reasons, where the employee is seeking to use the leave for their own reasons, they would be compensated at the full amount, subject to that $511 daily cap. And then the remaining reasons are the employee is caring for an individual who's subject to an order of quarantine or has been asked to be quarantined by a healthcare provider. The employee is caring for a son or daughter if the school or place of care of the son or daughter has been closed and the child care provider is unavailable to COVID-19 precautions, or the employee is experiencing any other substantially similar condition as specified by the Secretary of Health and Human Services. So for those last three reasons, the employee can be compensated at 2/3 their regular rate, subject to a cap of $200 per day. With regard to the use of the leave, there's not going to be any kind of carryover. And in addition, this appears to be a one-time use of leave, so that the employee goes out on this leave, and when they come back, even if they have leave remaining, it may not be available. That would be one of those things that the language of the Act is a little unclear, so that's the way it reads, but it may be subject to clarification by the Secretary of Labor. One of the things that is clear is that unused paid sick leave does not need to be paid out upon termination, and that the paid sick leave, by the way, has to be in addition to whatever the employer is already providing in terms of leave benefits. It is a new bank of leave. So that's really important to keep in mind. Let's see, the next, the paid leave requirement is going to sunset at the end of the year on December 31st, 2020. Oh, I actually do have a slide on the reasons that leave can be taken. So just wanted to give it to you, so now you have it. In terms of the notice and use of leave, there is no waiting period before the leave can be used. So many other sick leave laws at the state and local level might say you have to be employed for 90 days or 106 days or some other period of time before you can start accessing this leave, but this leave is immediately available. The employer can't require the employee to find a replacement to cover the missed work. And if other paid leave is available to use, the employee gets to choose the order of leave, but there's no reason to use this other leave because this particular bank of leave is COVID specific. So I don't see why an employee would choose to use some other leave. They'd rather save that, use this leave for the COVID related reason, and then save their leave for later. As for providing notice to access it after the first day of leave, you can require the employee to follow your normal call-in procedures for absences. In terms of the notice and record-keeping requirements, you are required to post the Department of Labor's notice. The Secretary of Labor is going to develop a model notice within 7 days, and then you're going to put it up wherever you put up your other model notices. Your FMLA notice, your EEOC non-discrimination notice, OSHA notices, et cetera. So that's usually in a break room or in the cafeteria, something like that. You are also required to retain whatever records related to the use of paid sick leave by your employees for 3 years. You violate the Act if you don't provide the paid sick leave, or if you take adverse employment action against an employee for filing a complaint or instituting a proceeding with the Department of Labor or testifying in such a proceeding. And violations of the Act are considered violations of the Fair Labor Standards Act. So the enforcement mechanisms under those under the Fair Labor Standards Act are going to be the ones that apply. In terms of what kind of remedies we're talking about, there are civil remedies and criminal penalties, a $10,000 fine and 6 months of imprisonment. In addition, either the Secretary of Labor or an employee can bring a civil suit and seek unpaid leave, liquidated damages, equitable relief, attorney's fees and costs, injunctive relief. So all of these things are penalties that could apply if you do in fact end up violating the Act, so we hope you don't. There are some things that the Act doesn't do. It doesn't contain any provisions that allow the employer to obtain certification of the need to leave, to verify those reasons, or to discipline employees if fraudulent use is confirmed. That isn't to say that employees can't do that. It's just that usually, the laws talk about your ability to do that. It doesn't happen here, so perhaps that'll be explained by the regulations. The Act does not preempt state and local paid sick and safe leave laws, so you'll have to make sure that you're complying with those as well. And the Act provides that it doesn't diminish the rights and benefits under any collective bargaining agreement. Notably, you're going to have to comply with your collective bargaining agreement and the Act at the same time, and they may not be consistent. So this might require unionized employers to provide notice to and an opportunity to bargain with unions over any required changes to collective bargaining agreement provisions or administration. And now I'm going to turn it over to Mark so he can tell you about the expansion to the Family and Medical Leave Act.
Thank you, Fiona. So quick refresher, those of you in the audience who employ 50 or more employees are used to having to comply with FEMLA. That is the current statutory threshold for coverage. And for those of you who meet that threshold, you need to provide eligible employees with up to 12 weeks of unpaid leave for certain qualifying conditions. And again, briefly, the conditions relate to things like pregnancy, to care for a child after birth or placement for adoption, to care for a covered relation, which would be a parent, spouse, or child with a qualifying serious health condition, for the employee's own serious health condition, and certain qualifying exigencies resulting from a military service member's deployment. And with the military aspect, you can even get up to 26 weeks to care for a service member who was injured or became ill as a result of their service. Also, what I think is helpful in terms of keeping in mind, current FEMLA, is that for an employee to be eligible, he or she has to have worked for the company for at least 12 months, don't have to be consecutive, and they have to have worked at least 1,250 hours during the 12-month period immediately preceding the date that leave is to begin. Okay, so now what do we have here with the expansion of emergency FEMLA? The first thing you see there is that it applies, just like the paid sick leave, to employers with fewer than 500 employees. So that means if you employ 10 people, you are covered, even though you would not be covered by quote unquote regular or current FMLA. Also of interest is that the type of employers that are covered or employees also include state and local government employees. So people who work for those entities are also covered by this expansion. There are two exemptions that you can see there. One is for certain healthcare employees and emergency responders. The other is for the less than 50 employee business if it would require, if their compliance would jeopardize the viability of the business as a going concern. As Fiona mentioned, the Secretary of Labor is called upon to issue regulations elaborating on those points. Also, uniquely different from current FEMLA is that point there that you see that employees are eligible for this benefit if they've worked for at least 30 days. So no more 12 months of employment, no more 1,250 hours in the 12 months preceding the requested leave. And as Fiona also said, with the paid sick leave, this provision will sunset as of the end of 2020. Now, special rules for healthcare providers and emergency responders. As I just mentioned, this was mentioned in the slide before, and this rule here that you see is rather duplicative of the exemption that I just discussed. But what this is saying here is that it gives employers the right to exclude these types of employees without waiting for regulations. So again, contrast that to the small business exemption that we talked about on the slide previously, where we're relying on the Secretary of Labor to issue regulations, as Fiona mentioned in her presentation. Here, you can go ahead and immediately utilize these exemptions, but emergency responders, is not defined. That's a problem. And the FMLA already has a definition of healthcare provider, and we can certainly turn to that. But what's interesting about that definition, which includes doctors and optometrists and chiropractors and a bunch of other, medical designations, that does not include RNs, CNAs, GNAs, medical techs, et cetera. So it'll be interesting to see what happens with regard to that level of healthcare provider, because obviously those individuals on the front lines of dealing with patients with the coronavirus. So what is the ability or the new FMLA reason where somebody can get this expanded FMLA leave that didn't exist up to this point? And that's right there on the slide, which is because your child's school or place of care winds up closing, and an employee in that sense has no child care provider, due to a COVID-19 emergency. The original House bill would have actually included quarantines of both the employee and the family members that got kicked out. Now, there may be coverage under FEMLA. We'll talk about this a little bit later when an employee is suffering from or diagnosed with COVID-19. We have to look at the definition of serious health condition under current FMLA. Many of you are aware that the mild cases of the flu, would not be considered to have a serious health condition. But obviously, we'll see what happens with respect to people suffering from the virus, and certainly someone suffering from an advanced case of the virus would qualify as having a serious health condition. There may also be coverage if an employee is ordered into quarantine by the government, and in that case, potentially could be subject to daily health checks. Healthcare provider may come to his or her house, check their temperature, do a check-in, what have you. Those would be considered to be medical examinations and would fall within the prong of a serious health condition where someone is having continuing treatment by a healthcare provider. So those are things that we'll be looking at as we proceed here. But keep in mind that with the potential coverage under current FEMLA, there will not be paid FEMLA available in those situations. Expanded FEMLA coverage as a result of the new law.
So I just want to emphasize that. I mean, Mark, what you're saying is that if somebody is taking the expanded FEMLA for school closures, they may get this paid sick leave that you're about to talk about in a moment. But if they're taking it for their own health or they're to care for somebody else who is sick, they don't get paid other than this 2-week pay that I just talked about, but they're not going to get this expanded FEMLA paid leave that you're going to talk about. Is that right?
That is correct, Fiona. Now, again, those of you who have been dealing with FEMLA all these years understand that employees can use paid leave concurrently with their FEMLA under most employers' policies. So someone who has built up a pretty good bank of either sick or vacation time, or PTO, however the company designates it, may, again, in the past, before this pandemic rose up for us to deal with, might have had quite a large portion of their FEMLA paid when they were out for their own personal illness, for example. But as Fiona alluded to, that is correct, that the paid leave under this statute will not kick in for an individual who is using FEMLA because of his or her own serious health condition. Reinstatement under FEMLA, we're going to talk about the actual pay provision in a second, but reinstatement is also a key component of FEMLA because, again, the aspect of the current law with its up to 12 weeks of leave provides that an employee must be reinstated to their former position unless something would have happened during their FEMLA leave that would have caused them to lose their job anyway. If a company, again, forgetting the layoffs happening as a result of this COVID pandemic. In the past, if a plant was having a reduction in force and the employee would have been reduced because of his or her seniority, for example, the fact that they were on FEMLA wouldn't have saved them from a job action that otherwise would have occurred. Here, the Act builds in this provision, as you can see there on the slide, that says that if you're an employer of less than 25 employees or fewer than 25, and again, remember that regular FEMLA, if you employed 20 or 15 people, you wouldn't be subject to FEMLA in the first place. But employers of fewer than 25 employees are not required to reinstate if these three conditions exist, which is number one, the job that the employee left no longer exists because of economic conditions or other changes in operating conditions caused by the public health emergency. Number two, the employer makes a reasonable effort to restore the employees to an equivalent position. And there's a whole body of case law and regulations that have developed over the years that FEMLA has been in place that would help an employer determine what is or is not an equivalent position if the exact job that the employee held is no longer in existence. And three, so that's common language that we're used to under FEMLA. Three is actually a new component here, which is also no position becomes available within a year. And if a position becomes available, the employer makes a reasonable effort to contact that employee. So again, under current FEMLA, there would be no obligation for an employer if it determined correctly that there was no job and no comparable job to return an employee to. That would be the end of the relationship. Here, the employer is required to make, again, quote unquote, reasonable efforts to contact the employee. We'll see how that plays out, obviously, but companies that are unionized, for example, they're used to laying people off and having what would be called a preferential recall list, likely something that would be in their collective bargaining agreement. And in those cases, the employer would be required to keep that list handy, and as job openings happen in the next, whatever the contract says, 6 months, year, 24 months, they would be required to go down that list and offer people the opportunity to come back to work. Here, you can see it's a 1-year time period, but that obligation will exist for employers under these circumstances. Let's talk about the actual paid leave. That's an important point, of course, for all of us. Fiona already talked about the paid sick leave that's available, 80 hours or essentially the first 2 work weeks. So under FMLA paid leave, the first 10 days are considered unpaid, but again, the employee has the ability to use the paid sick leave that Fiona talked about, or substitute any other paid leave that he or she may have available to them. So what about after the first 10 days? And this is a brand new concept for FEMLA as a separate independent right, as opposed to someone using a leave bank, is that the remainder of that time is paid. And as you see here, the pay is based on this up to 2/3 of the regular rate for the hours that the employee normally scheduled to work, to a max of $200 a day, or $10,000 total. So this is obviously a huge difference from current law, something that employers are going to now have to track and work through. I know in reading the comments about the pending legislation over the last week or so, there was a lot of concern by the employment community about the financial implications of both the paid sick leave and the FEMLA in terms of the money that essentially companies are going to have to front at this point. And there were some discussions about whether the money could come right from the government at first, or how that would play out. And obviously you could see this is what the Congress decided. But this money and these caps that Fiona talked about, which apply to both aspects of this, are fully reimbursed by the federal government to employers, and it will happen within 3 months. So when you pay your estimated quarterly tax payments, the employers can submit their paid sick leave expenses and their paid FEMLA as part of those tax payments, and at least you don't have to wait to the end of a year, for example, to get reimbursed for that amount. But still, that means the employer has to front the money for the approximate 3-month period.
I'm just going to clarify that it's the payroll tax credit it's not all taxes.
Yeah, sorry, thank you. On the paid FEMLA mandate, it's also got the same language about the multi-employer agreement that Fiona mentioned, so we won't belabor that, but there is employers that are part of those types of agreements are used to that. Now, this is obviously in addition to FEMLA. This becomes, an amended section of current FEMLA. While it's not clear in the new law, we think that the usual notice and certification requirements would apply to use of FEMLA for COVID-19 reasons. An interesting question that we've been kicking around here has to do with, and we're jumping ahead a bit in terms of talking about telework, but let's say, for example, you've got an employee who is able to telework and you've set him or her up, teleworking, and they've got a child of school age. So now you've got your person teleworking, and they're a job that makes perfect sense for him or her to be teleworking, and they let you know that, they've got a 10-year-old, a 12-year-old, and maybe the answer is different depending on how old their child is, and they say, oh, my child is, now home because the schools are closed. I am going to submit for my FMLA paid leave, and I'm going to ask for my 12 weeks as I'm allowed under this expansion. And you're sitting there thinking to yourself, well, wait a minute. You're not talking about like literally an infant. You're talking about a 12-year-old, a 14-year-old. That kid's going to be on the computer, either online doing their own schoolwork because that's how they're learning now, or maybe playing video games with their friends all day. And you're sitting there thinking, well, my employee really can't work because they've got a 14-year-old who's home who doesn't even want to spend a minute with their parents anyway. What do I say about that, Fiona?
Well, I think that the language of the law is that the employee needs to care for that child. It's not just simply that the school is closed, but both that the school is closed and the employee needs to care for them. So I think you can ask the questions about, what is it that the care is that you will be providing, employee, to that child who is 14 years old. Obviously, if the kid is young, that may not be a question that is appropriate to ask, but I think you can ask a question. If you get some pushback, I wouldn't push too hard, just given the climate, in terms of how much the Congress wants to protect the employee. But I think you can ask the questions up front.
So you're literally suggesting I can grill my employee about what he or she is doing to care for this 14-year-old and ask him what they're doing all day at home?
Grill might be a little harsh, but I think you can ask the question as to what the care is. Yes.
Okay.
We could, I just also want to ask about how this interacts with other paid leave benefits. Things like if you have existing paid leave to cover people's illnesses, or if people have PTO programs that cover any kind of paid leave, or STD programs, or even paid leave benefits that are available under state programs. So places like Massachusetts and New Jersey and California. I think Washington State has just passed one. Washington, D.C. has one, where these are like unemployment insurance benefits for people who are taking paid leave that would be otherwise unpaid, and they can apply to the state to get pay replacement benefits, insurance benefits, to cover that unpaid leave. I mean, what do you think about those kinds of things, Mark?
So I think that, you've identified a number of potential leave banks out there for people, but I think a number of those only kick in if the leave they're on is unpaid. So wouldn't that suggest that if someone's on, my 10 days of paid sick leave or my weeks 3 through 12 of paid FEMLA, that I can hold back those banks or those balances and try to use them after my 12 weeks of FEMLA?
I agree. I think that the paid leave mandates here are going to trump all the other paid leave or leave benefits that employees are entitled to. That this is going to come first, and then only after these new banks of leave are exhausted do these other benefits kick in.
And wasn't there some difference in the language between the initial bill and what ultimately was passed as far as whether or not the paid sick leave was in addition to other paid leave?
Yeah, originally as passed, it made it very clear that it was a new bank of leave, that existing paid policies are not going to, you can't rely on them. They took that language out, but they did leave in some language about how the act is not going to reduce any rights or benefits under existing employer policies. And certainly the House leadership, I actually have a memo from the House Ways and Means Committee leadership talking about the fact that this is a new bank of paid leave. So that is certainly the way it's being interpreted by the congressional representatives.
So just on that point, because I think it is something that the people listening here will need to pay great attention to. If I'm in a state that has a Safe and Sick Leave Act, and I've got to provide a certain number of days to the employee under the Safe and Sick Leave Act, my 10 days of PSL here for a COVID-19 related reason is going to be in addition to whatever I get under that state Safe and Sick Leave.
That is absolutely correct. And there's language too about how this doesn't reduce any rights or benefits under state law. So absolutely.
Okay. The next slide is, we jumped the gun on this one a little bit, but just so you can see there that talks about the tax credit for these numbers. So again, we understand that they're going to be hardship, obviously, especially for smaller employers, but there is, the reimbursement, as I said, that likely will be on a quarterly basis. There is not full reimbursement for really highly paid people, so you can see there, $511 per day is, a little bit over $2,500 for a 5-day work week. If you've got people making $3,000, $4,000 a week, you would only be obligated to pay up to that $511 if it's something for their own condition. And obviously, if they're taking off because of the family member situation and the $200 limit applies, then it may be well less than what their full pay is. But these are the numbers that Congress has decided upon and where the tax credits, will lie. We know that some legislatures are looking at this and thinking about setting up funds or emergency loans or things to help bridge the period between, when the tax credit kicks in. Obviously, that'll be a state-by-state situation, and we'll see if anybody, does anything in that regard. Unemployment insurance, I can tell you that Fiona and I, when we talk with our clients, have gotten a lot of questions because, of course, the number of companies that are instituting layoffs or furloughs. The Act provides emergency administration grants to states to assist with processing and paying unemployment insurance benefits, provides the state demonstrates steps it's taken or will take to ease eligibility requirements and access to unemployment compensation for claimants, including things like waiving work search requirements and the waiting week and non-charging employers directly impacted by COVID-19 due to an illness in the workplace or direction from a public health official to isolate or quarantine workers. So essentially, the federal government here through this legislation is trying to make it easier for states to allow employees to obtain unemployment insurance more easily if they're ill or ordered into quarantine due to exposure to COVID-19. So that is a development that I'm sure we'll be seeing states throughout the country acting on very quickly, depending on when their state legislatures are in session. Some states have already passed emergency legislation to cover these issues.
And actually, the DOL issued some guidance on unemployment benefits and saying that the states have the discretion to interpret their own laws to include such benefits, so they don't even have to wait for their state legislatures to act. Really, the commissions in each state can make that decision according to the DOL.
Okay, so here I'm going to turn it back to Fiona, who's going to tell you about some facts about coronavirus. I know we're seeing a lot of this in the news, but I can just tell you in conversations I've got with clients from time to time that some of these basics still seem to be not always at everyone's forefront, so I think it's valuable for Fiona to run through this quickly.
Right, and obviously, what you've heard in the news, the illness isn't always severe. It can be very mild. There could be almost no symptoms or no symptoms at all. And that they expect that the person-to-person transmission is occurring through respiratory droplets of 6 feet. And I will tell you that Mark and I are sitting 6 feet away from each other right now. And that there is possible transmission through hard surface contamination. It's not clear how long this virus will survive. I think they've done some studies, and it can survive up to 3 days in perfect conditions, but usually it is less. And it is not a concern as to paper and cardboard, that it doesn't seem to last there. And I love this. They've made it clear that they don't think pets can either contract it or transmit it. I suppose if you cough all over your dog and then somebody else plays with your dog, they could get it if they do it within a couple of minutes. But on the whole, you don't have to worry about your pet. Certainly, the symptoms are important. That there is a fever, cough, shortness of breath. All three things. Those are the symptoms that people can exhibit. There are significant complications of pneumonia, kidney failure, or death. So where do we start? We start with the CDC. They're the definitive authority in the United States. And they're going to determine if a situation rises to a level of a direct threat that's going to allow greater latitude in medical testing and inquiries under the Americans with Disabilities Act, and I'll talk a little bit more about that in a moment. And all the other federal agencies are going to look to the CDC in terms of, what are the appropriate standards of behavior. And the CDC, in terms of testing, they're going to rely on state and local departments of health. Those health departments will provide guidance when there is infection or possible exposure. So I really encourage people to reach out when you have questions about possible exposure in the workplace to these departments of health, because they've really been tremendously helpful, Mark. I don't know if you've had that experience, but if you call up and say, I have an employee who has been exposed and they're coming into the workplace, is that a problem? Or I have an employee who actually has contracted COVID and they exposed their coworkers, what do we do now? And they're really great about providing guidance on what those next steps are. I do want to focus in on the testing for a moment, because I've heard people say, well, I'm just going to send my employee to get tested. And I want to just let you know, it's not quite that simple. You can't just order somebody to be tested. The Department of Health or the employee's healthcare provider has to order the testing, and they're not going to do that unless the individual meets some very specific criteria. There's lots of talk about making widespread testing available. There's all these, drive-through testing facilities that are popping up, but the testing equipment, the kits are still pretty limited. So they are saving those at this point, and not just testing anybody who wants to have a test, unless you happen to be famous, in which case apparently you can get such a test.
If you're in the NBA, you can get a test.
Or in Congress, for that matter, now that some congressmen have started testing positive. So if a test is ordered, the employee is, the sample is going to be taken by the healthcare provider or maybe by a particular facility. And then those samples are taken and they're going to be sent off to particular labs that will do the actual testing. I just also want to note that not all healthcare providers can do the test. I mean, most have relationships with these labs that can do it, but not everybody might. And so, it will vary from healthcare provider to healthcare provider, but most of them can order the test if it's necessary. So workplace hygiene and infection. There is no specific OSHA standard regarding things like COVID-19, these respiratory diseases, but OSHA's general duty clause applies to everyone. So an employer has to furnish a place of employment that's free from recognized hazards that can cause death or serious physical harm. And that requires you to conduct workplace hazard assessments and take control measures. I'm not talking about particular industries like healthcare that do have additional requirements and standards. That's a completely different webinar. We're not talking about that here. So in terms of workplace hygiene and disinfection, I'm not going to go through these things because, frankly, CDC spells this out on their website and their guidance. And we do have a link to the CDC website at the very end of this presentation. But certainly you probably have heard about all of these things, and I'm just going to leave it to you to read later. Same with this slide. In terms of personal protective equipment, I do want to focus in on that because that's really an issue that's come up over and over and over again. And certain employers, such as in the healthcare industry, do have to provide personal protective equipment or PPE, such as gloves and masks. But other employers don't have to permit the use of these masks because under OSHA's respiratory protection standard, a respirator, which includes safety masks, have to be provided by the employer when such equipment is necessary to protect the health of such employees. And the definition of respirator does not include things like the surgical mask, those little, fabric-y, papery, rectangular things that tie over the ears or around the head. But they do apply to the N95 masks that everyone's been talking about, the things that you can't order on, Amazon anymore because everyone's grabbed them. Those are much more specialized masks, and they do prevent the transmission of much smaller droplets. Those would be considered respirators under the OSHA standards, so it's important to remember the distinction between that. So under the OSHA standard, the rule provides that an employee has to provide the respirators when the equipment is necessary to protect the health of employees, but then an employer may provide the respirator at the request of employees or permit employees to use their own respirators if you determine that the respirator use will not in itself create a hazard. So you can allow it, but that also means you can decide not to allow it. So employers have decided not to allow it for a number of reasons. Maybe it causes fear and anxiety in the workplace, and besides, the healthcare officials are saying, look, this is not stopping the infection of well employees. So there's really no point to having well employees use the mask to try and avoid infection, because that's really just not helping. Plus, it's reducing the amount of masks that are necessary in the healthcare industry. I mean, the hospitals are saying they're running out of these masks, and we need to save the masks for the healthcare providers who are on the front line of dealing with the COVID patients to use these masks. The time that you might have to allow the use of the mask is if somebody has a disability within the meaning of the Americans with Disabilities Act, and you're required to provide a reasonable accommodation that enables them to perform their essential job functions or allows them to enjoy the privileges and benefits of employment. And so a mask or gloves under those circumstances might be a reasonable accommodation for a particular disability. But if that's the case, you're entitled to get medical information from the provider, the healthcare provider of the employee, establishing that disability and also showing how that mask or gloves would be a reasonable accommodation. If you do allow somebody to use a mask or gloves in the workplace, and again, I'm talking about masks that are the N95, not the surgical masks, there are going to be some requirements under OSHA. So if you allow somebody to use a mask, you're going to have to give them Appendix D of the OSHA respiratory standard. That's all you have to do. You just literally hand over Appendix D, which tells them, that they ought to know how to use the mask properly. But you have to do that. With respect to gloves, you have to conduct training under the PPE standard. Putting on a glove may not be so, take a whole lot of education here, but taking off the glove and disposing of it properly is pretty critical, because if you don't, that infection could be spread. So it's really important to do that training, even though it may not be terribly complicated training. Some of the things that you now are talking about that you've never talked about before: social distancing. As I said, Mark and I are sitting 6 feet apart. So some of the things that you might want to think about in terms of social distancing is moving desks or work areas as far away as possible from each other, having folks come and go at different times to minimize the contact, so working these staggered shifts. Split team assignments, meaning that some team members alternate coming in and out of the office and other people are working at home, so that, again, we're minimizing the contact. Telecommuting, which Mark is going to talk about more in a moment, and this is something that you can try out to see if it works. We actually had a sample day yesterday at our offices to see if we could all work from home, and I think that is the determination that it works, and we're going to be really focused on that for the most part. Some employers offer food or meals to their employees as a courtesy, and that is probably not the wisest thing to do at this point because of the possible infections. If you do want to do that, we recommend that you do it on a grab-and-go purpose or manner. So now I'm going to turn it over to Mark to talk about telecommuting.
Thank you, Fiona. So there are a host of logistical and legal issues that can be related to telecommuting. Telecommuting is obviously not a new thing. It's something that we often talk with our clients about, and in the past, I would say it largely comes up when we're looking at potential accommodations under the ADA. I've worked on many cases and scenarios where the employee is arguing that telecommuting would be a reasonable accommodation for them, and obviously in some instances, the job can be performed remotely. In others, it really can't, and even though they may medically be able to do the job from their home, it was a determination that the person could not perform the essential function. So this is not a new concept in the employment setting, obviously. So if you've got employees that are already set up to telecommute, and Fiona gave her example of our law firm, for example, the lawyers have been able, based on technology, to telecommute for quite some time. Not so much with our administrative support staff. So you've got a number of people that may not be set up at home to do so. And you're going to have to look at, securing equipment and supplies and maybe even internet access. In some states, and just to give you a few examples, California, because it's always California, Illinois, Iowa, New Hampshire, the employer is responsible for all business-related expenses. So obviously that may kick in here if we're doing some type of telecommuting. If the telecommuting is actually a reasonable accommodation for someone, under the ADA, then typically you'd have to pay those expenses as well. In other circumstances, the employer could require the employee to bear additional expenses associated with telecommuting. But keep in mind that if you've got a non-exempt or an hourly employee, eligible for overtime under the wage hour laws, and you're going to have that person working from home, you cannot require the non-exempt employee to pay for business expenses, where doing so would reduce their earnings below required minimum wage or overtime compensation. Exempt employees, those who are not subject to required minimum wage or overtime, you have to be cognizant of the fact that additional phone, internet, or other expenses might be viewed as an impermissible deduction under the FLSA's salary basis test, which of course is an important part of qualifying someone as a white-collar exemption to make sure they're paid on a salary basis. So keep those in mind as you move some of your team members to telecommuting. Employers should also be thinking about security issues, both for the equipment itself and for company information. So as you go into a world where you've got all these computers out there, is your system, is the employee system protected from viruses and malware? Sometimes, obviously, the employee is using a company-issued laptop, and in those instances, it's likely that the company's IT department has prepared the laptop and made sure that various, virus protections are on the laptop. Some instances, an employee may be using his or her own computer, but obviously, you've got to be concerned about that, because once they dial in or log in remotely, your system's only as good as the weakest link. Also need to keep in mind that some information that that the employees will be using working remotely, health information, for example, have security requirements under the law. And what about employees working with confidential documents? They may be receiving them and printing them at home or whatever. And so when you're in the office, you can try to have various protocols established for confidential documents, whether it's stamping things confidential, literally having those documents kept under lock and key, or having people having to return the documents after a meeting, for example, where you review the document with a team. So you want to be thinking about how do you secure the confidentiality of these documents when people are working, numbers of people are working remotely all over the place. Also keep in mind that back to the FLSA, you've got to track time worked by non-exempt employees. So if you've got an hourly worker who is working remotely, you need to use the best feasible means of having that person record and report their working time. If you can't do it, if you don't have any way to log in into some type of app or electronic system, they have to at least keep a paper record of their starting and stop times, and including meal breaks. And it should never always say 9 to 5, 9 to 5, 9 to 5, day after day, because nobody ever works the exact same hours day after day. You want to make sure that, again, your hourly people know that they need explicit permission to work overtime. You don't want someone all of a sudden sitting at their computer for 15, 20 hours a day, and you're all of a sudden on the hook for time and a half for those hours after 8. Also keep in mind that from time to time, even with teleworking and social distancing and what have you, the employee may need to come into the office from time to time, get files or what have you. Normally when someone drives to work in the morning, that's normal commuting time, which is not working time, not compensable. But if you had a situation where an employee left their house in the middle of the day to come to the office for whatever reason, that drive time would be compensable.
I'm just going to jump in here and clarify, because you said, overtime for hours worked over 8. And, that may be the case under some state laws, but generally it is overtime worked for over 40 hours in a work week, which is usually 8 hours a day. And I think that's really what you meant, Mark, but just in case anybody got confused out there.
Thank you. I did not mean to suggest it was a daily overtime, and Joan is correct. It's usually a 40-hour-a-week standard. Also keep in mind that OSHA has said it's not going to regulate home offices, but if an employee becomes injured while working from home, that's a reportable event, and workers' comp may apply as well. So just again, you want to, if you do establish telecommuting, make sure that you've got clear standards in place and you can hold your employees to those standards. And, again, pre-coronavirus, most employers that had telecommuting policies, and they would consider it in many cases to be a privilege for someone to be able to telecommute, there would be language in the policy that would indicate when an employee may lose the right or the privilege to telecommute. For example, oftentimes if they're subject to discipline and in some type of disciplinary protocol, they may be required under the policy to come back to working at the office. So you can still cancel, again, we obviously are concerned with COVID-19 and making sure that we are complying with, all applicable health requirements. But just generally speaking, people just don't get a telecommuting right forever as a matter of, privilege. One more thing, and I know I mentioned earlier that this is a concept that comes up a lot in the ADA concept. There's been some discussion about, will employers be able to, once we're through this, hopefully in the not too distant future, will you be able to say to someone that I can't have you telecommute, when they make an ADA accommodation request, and they say to you, well, just remember back to March of 2020 when literally the entire company was telecommuting and you didn't go out of business. What do you mean I can't telecommute or that you can't accommodate that? So we think that the better course is to specifically advise employees that something to the effect of letting them know that these arrangements are expected to be short-term, that we'll continue to monitor what the CDC and health officials are telling us about the need for remote work arrangements. Employees should not assume that there's any specific period of time that they'll be guaranteed teleworking, and that we may require them to return to regular in-office work. And also to mention that this is once more necessitated by the extraordinary situation we find ourselves in because of the coronavirus, and that we understand that employees might not be able to perform all the essential functions of a job, but during this temporary period, we're going to allow them to work remotely. So I think that would set you up nicely for being able to say with a straight face down the road that, look, we need you to perform the essential functions of the job, and leave aside what we did during the coronavirus pandemic. We're now back to business as usual, and we do not believe that you can perform all the essential functions.
Unless, in fact, they could perform the essential functions from a telecommuting perspective. So, we shouldn't just automatically deny it. It needs to be a case-by-case assessment.
Yes. Business travel. So I know we mentioned at the outset some of the pronouncements from the White House about travel. Again, various states are stepping in here. Just today in Maryland, there have been further restrictions based on the use of public transit, including MARC trains, which go from Baltimore to Washington, for example. So right now, what we're seeing is, of course, non-essential travel is not being done by really anybody that we're working with. And certainly that's the best advice right now. And we know, back to our discussion about telecommuting a little bit, the ideal is that people are looking at technological options. So can you teleconference? Can you video conference? I'll just say from a personal standpoint, I do a lot of collective bargaining on behalf of my unionized clients. There is some discussion about whether or not that's the kind of thing that's best done in person, but because of the current situation we find ourselves in, I've been doing a lot of telephonic bargaining where all the participants, both from the company and the union, are calling in, and we're doing it that way. It's not as good as face-to-face, but again, because of the pandemic, that's what I'm doing. I know that's what a lot of companies are doing as well. So there's a lot of medical advice, CDC advice, what have you, about avoiding travel, and this just goes with it.
I just wanted to mention, in terms of the technology, you may want to do some training for your employees on using these technological advances. I know I personally am kind of a Luddite, and so I really found it challenging when we first started using the teleconference capabilities, and I actually had to call my teenage son down from his room to help me get hooked into a business meeting recently. So that was a little embarrassing, but now I know how to do it. So just keep in mind that not everybody may have the skills up front, and you may have to do a little bit of training.
Well, in that case, it sounds like your son is caring for you, and maybe he's entitled to some more.
You betcha.
Technologically challenged mother.
Oh my goodness.
Okay. Again, with business travel at this time, and again, these things are fluctuating seemingly minute by minute. Businesses could require essential business travel. So that leads to the question, of course, what is essential business travel? It's not something that's defined, in this statute or anything like that. But what I will say from what I've seen in the literature is that essential business travel is situations where business cannot reasonably be conducted without face-to-face interaction or a visit to a specific location. So again, I know that people could probably even quibble with that to some extent as to whether or not something truly could or could not be done unless you were face-to-face with the other party. But that is obviously something that a lot of businesses are dealing with. Now, what if an employee expresses concern about the traveling? And let's say, for sake of argument, that we have determined it to be essential business travel, and we've got an employee that is reticent to travel. What do you do now? And again, like everything else, I would say this is something that just seems to be an evolving type of issue. And most of the companies that we're working with are obviously, they're just trying to work through this like everybody else. And we've seen a lot of understanding and willingness to try to find a common solution from the people that we've been working with, which is obviously good. So I think what you look at here is, okay, well, where is the location? What is the means? Are we talking about getting your car? Are we talking about flying? Obviously, flying itself, the airlines are still running on a limited schedule, but that is also a kind of a day-by-day situation to see whether or not air travel is even feasible. We had a client who had employees several states away on business. They had flown there, at the start of the business trip, and that was before the pandemic started. And they were not comfortable, or one particular person, not comfortable flying. And he offered to take the rental car that the company had gotten him for the business trip, drive it back to, his home state, that he would pay any additional costs, any drop-off fees or what have you, but he was unwilling to get into an airplane. And it would also mean that he would be a day late coming back to work because the drive would take, more than 24 hours. In that instance, the company went ahead and allowed him to do it. And again, trying to be reasonable about it. So you also look, of course, at the risk factors. The person you're talking about, the employee, what is their age? Are they over 60? Do they have compromised underlying medical conditions? Someone who would place them in that risk group. Now, we say all that, and then obviously that's what the CDC has said. I just saw something before we walked in here about the fact that, I can't remember if it was in a particular state or in the country, but that in one instance, most of the patients at the hospital were under 44 years old. So, we'll see who had, been diagnosed with a positive COVID test. So we'll see how that plays out. But right now, we know what we've been told about the people with the risk factors. And
I just wanted to talk a little bit about this age 60 and over cohort, because there's some discussion about that, where some employers are saying, well, can I just tell all my over 60s to go home because, I don't want them exposed to COVID in the workplace? Or conversely, can we have some sort of policy where those over the age of 60 can ask to work from home, even though we're not going to let anybody else work from home? So I just wanted to talk a little bit about that, because that is coming up over and over again, because people are aware that under the Age Discrimination and Employment Act, you're not supposed to treat people differently based on their older age. And so what is your take on this, Mark?
Yeah, so Fiona is right. There was something that we discussed here internally among our partners. I'm not sure I've seen anywhere where someone seems to have the definitive answer. What Fiona mentioned, I think, is the factors you would look at this. Again, from all that we're seeing and from the CDC, certainly someone over 60 who has compromised underlying medical conditions, that seems to be a pretty clear-cut case that person would be, either if he or she wanted to not come to work, or the employer was concerned about some of the situations in the workplace, that would be possibly an easier one to deal with. I know that in a couple policies I've just been reviewing with actually companies that are organized with unions, but I'm not sure that part is that critical, that they are allowing anyone over 60 and anyone with a compromised underlying condition, regardless of their age, to choose to work remotely and pay them, or if they can't even work remotely, to actually pay them for their time off.
And I think that's actually, really a defensible position at this point, given the instructions from the government with regard to these folks over 60. But I just want to clarify that I do think it's dangerous, though, if an employer says, hey, all you over 60 people, we're sending you home. The rest of you get to stay here. And the reason we're doing it is because we're afraid that you might get sick. That's a really paternalistic view, and I think that would be problematic if an employer chose to take that approach, because not everyone over the age of 60 is going to get sick, and not everyone over the age of 60 may have it severely. And I do think that you need to be respectful of people over the age of 60 who want to stay in the workplace if that is their choice.
Yeah, not to beat this to death, but I do think this is a very interesting issue, and we're all aware of people we work with where people may be in their 30s, 40s, or 50s and appear to be in pretty poor health, overweight, maybe medical conditions you're aware of, and others who are 60, 70 or older who appear to be perfectly fine. Again, you don't always know what's going on with someone, but I think that is an interesting issue. And, you know, it'll be interesting to see what other litigation arises out of this whole pandemic and how people will be about filing claims and going to the EEOC. But I do think this is one area where an employer could really, you know, run afoul of the law easily.
So definitely call your attorney if you're thinking about doing one of these things.
One more question about travel before, again, I turn this back over to Fiona, is personal travel. So we talked before about business travel, essential travel, whatever. You know, there's obviously a concern, social distancing, groups of 10 or less. You know, if your employee is going to, on the weekend and going someplace out of state, what can you or can you not do about that as an employer in terms of whether or not you have to let that person back in the workplace? Now, some states, as we indicated up there, have legal off-duty conduct laws that simply say, you know, you can't regulate what a person is doing out of the workplace. I think whether you're in one of those states or not, certainly employees traveling to, you know, level 2 or 3 countries, for example, you'd have everybody, obviously, to put them into some type of self-quarantine before they return to work. People that go to areas of outbreak, so there are obviously certain areas within the United States that we're aware of, New Rochelle, New York, Seattle, others where there have been, you know, significant outbreaks where, again, I think you could apply the same criteria. I can tell you that we get a lot of calls from clients just in the last couple of days about employees who are concerned working with coworkers who maybe have a relative who's sick or whatever. So you can imagine that, I mean, they don't know if they have COVID or not. They're just thinking coworkers, you know, child is sick. I could imagine, though, that if you found out a coworker had gone to one of these areas where there had been a heightened instance of outbreak, that the rest of the workforce would have some concerns about being in any kind of contact, let alone the social distancing contact. And finally, I think that we think it's clear that you can ask your employees to self-monitor and report if they're traveling somewhere. And what if, you know, you wanted to say to someone, well, you really can't go there because you're kind of critical to our operations or what we're doing next week in the office or the plant. And if you go to XYZ place, you're going to wind up in a quarantine. So I'm telling you not to go there. Again, if you're not in a state that has off-duty conduct laws, probably can do that. So I'm going to turn it back to Fiona to talk about screening employees.
So the Americans with Disabilities Act prohibits employee disability-related inquiries or medical examinations unless they're job-related and consistent with business necessity. And generally, a disability-related inquiry or medical examination is going to be job-related and consistent when an employer has a reasonable belief, based on objective evidence, that their ability to perform essential job function is going to be impaired by a medical condition, or they're going to pose a direct threat due to a medical condition. And information that you get related to this is confidential information that you have to keep in a separate medical file under lock and key, only disclosed to, you know, certain people, both under the FMLA and the ADA, assuming the FMLA is involved. And if you're a covered employer under HIPAA, then you would also be, you know, subject to keeping it confidential under that law as well. A direct threat is considered a significant risk of substantial harm to the health or safety of the individual or others that can't be eliminated or reduced by reasonable accommodation. And assessments of whether or not somebody poses that direct threat in the workplace has to be based on objective factual information and not on subjective perceptions or rational fears. The EEOC's regulations identify 4 factors to consider when determining whether or not an employee poses a direct threat. So they look at the time, the duration of the risk, the nature and severity of the risk, the likelihood that harm will occur, and the imminence of the harm. And whether or not a pandemic influenza like COVID or rises to the level of a direct threat depends on the severity of the illness. So if the CDC and state or local health authorities determine that this illness is more like a seasonal influenza, like the H1N1 back in 2009, it's not going to pose a direct threat. It looks like we're moving in the direction of a direct threat, but at this point, it's not yet there. Just declaring it a state of emergency doesn't make it a direct threat. I will say we, you know, at this point, we're coming pretty close to a direct threat, I'd say, but just not quite there yet. But realistically, do you think the EEOC is going to go after anyone right now if we're wrong about it being a direct threat, Mark?
Well, since our government agencies are barely open, I think probably not. But we know, those of you in the audience who have had EEOC cases and charges pending for, 1, 2, 5, 20 years, you understand, of course, that someone could file a charge and we'll be arguing about it 2 years from now. So I guess 2 years from now, maybe they will.
Okay, well, anyway, you are entitled to ask non-medical questions, and the EEOC says that these are non-medical questions, asking employees to report if they've traveled or had close contact with someone who's traveled to an area of outbreak, whether or not they've been exposed to COVID-19 or one of their family members has, and whether or not they're experiencing symptoms of the illness. That is an okay question because that's not a medical inquiry. And if the outbreak becomes a direct threat, and the CDC says it's a direct threat, you can ask whether or not an employee has a compromised immune system or chronic health condition that makes them more susceptible to COVID. Not so that you can put them out of the workplace, but so that you can be aware that they might be more susceptible for business planning purposes. And you can always require employees to report if they've been diagnosed with COVID or if a family member or household member has been diagnosed with COVID, because that is a direct threat to the workplace.
So Fiona, I'd like to ask you a question about that because I know that's come up a lot, which is if an employee tells you that a relative has been exposed, what do you do?
You call the Department of Health. That is where I would start. In all honesty, that is where I would start, because I think the Department of Health has been tremendously helpful, again, in determining what that risk factor is in terms of the workplace and what activities you should be taking with regard to your other employees in the workplace. But I'll get into that a little bit more later. In terms of, we'll go taking the temperature. This is a major one, and up until Tuesday, the EEOC was saying that you could not take temperatures in the workplace because that was a medical examination, and so employers generally couldn't do it unless there was, healthcare employers could, but unless there was a direct threat. On Tuesday, as we were actually doing another webinar, we found out that the EEOC had changed its position. So go forth and test your employees now. That is totally fine according to EEOC, but do be aware that, this temperature taking may not necessarily indicate that somebody's got COVID, because there are reasons other than COVID that people may be running temperatures, or they may not be running a temperature at all, but still have COVID. So that is just some stuff to keep in mind. In terms of screening employees, we've had questions about whether somebody could have a doctor standing at the entrance to the building and watching employees as they come in to see if they're exhibiting symptoms. That doesn't seem like a really very effective way of determining if people have symptoms, and this would be considered a medical examination that is prohibited unless it's job-related and consistent with business necessity. It seems like there are more effective ways to get that information, so the EEOC would say that this was not an appropriate way of trying to determine if somebody has COVID-19. And you want to make sure that you're not targeting employees based on race or national origin for screening, or, if people are complaining that they don't want to work with somebody because they're Asian, for example. That really was more of an issue early on. Now that it's so widespread, we're not really seeing much in the way of targeting Asians for discrimination the way we were initially. You can screen visitors. Go forth, screen all you want, because there are no employment laws that apply to your visitors. And in fact, many state and local orders are requiring certain employers to prohibit visitors to the workplace or limit visitors to the workplace at this point. Sick employees, what can you do? Some of you may have noticed that Mark has been coughing like that throughout this presentation. And if he were my employee, could I send him home because he's exhibiting a symptom of COVID? Well, I do know for a fact that Mark's cough is not connected to COVID. He does have a chronic cough that sometimes gets a little worse with allergies. But if I did not know that and he was exhibiting this symptom, I could send him home. And under OSHA, if an employee in the workplace is suspected of having COVID, you have to remove them and immediately isolate them, put a mask on them if you've got one, and send them out of the workplace. So you also, you can get information from the doctor regarding whether or not the employee is able to return to work. The ADA allows you to get a fitness for duty return to work clearance. The FMLA also allows employers to get fitness for duty certifications. There are very specific requirements for when you can do that. So, consult with your attorney to make sure that you're doing it appropriately. The CDC, however, is suggesting that you suspend that requirement because the healthcare providers are, as this gets worse, are simply just going to be too burdened to provide that kind of individual clearance to return to work. And remember, again, that you need to keep any medical information that you get under lock and key. If the employee is diagnosed with COVID, there's a question of whether or not the ADA would apply. Like the flu, a mild case of COVID doesn't rise to the level of a disability under the ADA. A serious case of COVID might. It's going to depend on individual circumstances. And if they're disabled under the ADA, you're going to have to provide reasonable accommodations, including leave and telecommuting. Of course, those things are being provided now, and you're going to have to provide them under the Coronavirus Response Act in any case. With regard to the FMLA, again, as Mark had said earlier, it's going to depend on whether or not the illness rises to the level of a serious health condition. We would say, you should err in the favor of coverage at this point, but not force people on FMLA if it turns out that they were not actually entitled to it, because then if you ran the FMLA at this point for something that wasn't actually covered, you've just denied them the use of that FMLA for something that would actually be covered in the future. So be careful with regard to designating this as FMLA. In terms of sick leave laws, they're definitely going to apply in this situation that somebody has COVID. Certainly the Coronavirus Response Act is going to provide those new banks of sick leave. Well, the paid sick leave will apply. The paid FMLA will not if somebody is sick. States and local jurisdictions have sick leave laws that you may have to comply with. And you may have employer policies providing sick leave that they should be allowed to tap for purposes of COVID. In addition, some states are passing COVID-specific laws. So Colorado just passed an emergency law requiring employers to provide 4 days of paid sick leave to employees with flu-like symptoms being tested for COVID-19. So be aware of these one-off emergency legislation. So in terms of paid family leave benefits laws, I was talking about those unemployment insurance-like provisions that some states have. Those may apply if somebody is sick or if their family member is sick, certainly. Sometimes there are carve-outs that you can use it for family members, but not themselves. Depends on each state's law. STD or paid leave policies might apply. You want to make sure that in this circumstance, I would be really loath to say to somebody, you don't have any leave, we're not going to give you unpaid leave, and we're going to fire you. Provide the unpaid leave if you don't have paid leave. And if you can afford it, you might want to consider paying leave. As Mark said, one of his clients is doing that. So continue the regular pay, or maybe allow them to borrow from their paid leave entitlement if they've already exhausted their paid leave, or maybe try and do some sort of partial payment if possible. The Coronavirus Response Act is giving the state discretion to interpret their unemployment benefits. And I know that in Maryland, they're talking about allowing employees to tap unemployment benefits if they're sick with COVID. So, just be aware that that is a state-by-state issue. If an employee has contracted the virus at the work, they may be covered by workers' compensation. It might be a little bit difficult to determine if they contracted it at work, but certainly if they were exposed to somebody at work and then got sick, that would indicate that it is a work-related requirement. If it is a work-related requirement or work-related condition, the illness has to be reported on the employer's OSHA Form 300 and Form 301. And you may be required to report that infection to OSHA if it's work-related and the infected employee is hospitalized or inpatient. You have to do that within 24 hours. If the employee actually ends up dying, you have to report it within 30 days of the work-related incident. You certainly want to report it to the Department of Health, although they probably already know. As I said, the departments really have been tremendously helpful in providing next steps. If an employee has contracted COVID-19, you will have the obligation of communicating with your fellow employees and visitors who had contact with the sick employee. You cannot disclose their name. I want to emphasize, likely everybody in the workplace is going to know it was Mark who was sick with COVID, but you cannot say it was Mark who was sick with COVID. You can certainly recommend that they self-monitor. You may want to allow them to quarantine depending on what the health department recommends, and conduct some deep cleaning of the work area and the areas that they may have exposed other people to, and be prepared for publicity, because certainly that is heightened interest right now. In terms of employees who are caring for a sick family member, it may or may not be FMLA. As Mark mentioned previously, sick leave laws are certainly going to apply, including the Coronavirus Response Act. Paid family leave benefits laws might apply, and if none of these apply, there are no protections. But again, I would not fire somebody who needs leave to care for a sick family member who has COVID. So consider providing that unpaid leave and using paid leave or paying out leave that as a courtesy. Employees who have been exposed to COVID-19, again, consult with that Department of Health. You can require them to work and self-monitor for low risk. At least that's the recommendation of the Departments of Health at this point in time. That may change as the situation gets worse. Whether or not you communicate with other employees may depend on how widespread that knowledge is within the organization. But at this point, the Departments of Health were not recommending that you had to do that. I do think that it might be wise. I'm going to let Mark now talk to you about employer-required quarantines.
Thank you, Fiona. Originally, under an earlier version of the Act, quarantines would have been covered by the paid sick leave provisions, but that is no longer the case. What is interesting is that unemployment insurance benefits may apply depending on state law interpretation, because the quarantine might be viewed as a temporary layoff. Typically, if you're not ready, able, and willing to work, that would be a disqualifier for unemployment. But as Fiona was saying, some of the states are actually allowing people that are sick with COVID to qualify for unemployment. So again, certain situations, the employer is implementing the quarantine, and other situations, obviously, it's the government. And if the government issues the quarantine, as I touched on briefly before, you may have some FEMLA application, because if someone is subject to a daily check, that might constitute treatment by a medical provider and qualify under the serious health condition prong of FEMLA leave. It's also interesting that some state laws will provide employment protections for employees under a healthcare or government mandated quarantine. So even before the COVID pandemic, I can tell you that a number of states, including Maryland, Maine, New Jersey, New Mexico, South Carolina, and Texas, have specific statutory language that an employer may not fire an employee who is under isolation or quarantine as ordered by the state government. Again, we're not seeing a rash of our clients looking to fire people in these situations, but just keep in mind that that would be obviously a public policy violation. Again, with respect to government and quarantines, there may be expanded unemployment insurance to cover. In fact, frankly, whether or not that winds up being government as well as employer required, but we'll see what the various states do with regard to that. You want to look at your local laws, both on the state level and the locality level, to see if there's sick leave laws that would allow use of that time for quarantines. Obviously, we need to update our slide because the CRA has been enacted.
Sorry about that.
There, of course, is paid sick leave under the CRA. Slide 51 will be updated. And keep in mind the idea of telecommuting and quarantines. So obviously, someone who is in a situation where he or she could still work, although quarantined at their place of residence, they may be in a position where they can telecommute. And as I think we talked about before, realize that exempt employees are paid for, under the wage hour laws, paid for a full week in which they do any work. So if they spend a little bit of time here or there checking email or responding to emails or obviously on some work calls, you're going to wind up having to pay that person for the entire week. The hourly folks, non-exempt, are paid for any time they specifically work. And if you've got an exempt employee who is quarantined, and we're going to talk about both exempt and non-exempt in the situation. So you've got the exempt employee who is quarantined. You could tell that person, you are not to do any work. I'm not going to, authorize you to do any work. You will not be paid because you're not going to be doing any work. You can require those people to use vacation or PTO to cover partial weeks, and they'll still receive a full week of pay. We're just looking at the normal wage hour rules there with respect to exempt employees. And, there are the abilities to deduct a full day absence under sick leave policies. And once again, CRA was enacted, so they are going to receive paid sick leave. And finally, your hourly folks, I know we've hit on this a couple of times, but it's an area where companies can easily run afoul of this. And with respect to the COVID pandemic, you could do it here just as they do elsewhere, which is, pay for hours worked. Be sure to consider for unionized employees what you may or may not have to do based on the union contract. You never know until you look at it what kind of crazy provisions might be in a collective bargaining agreement that you hadn't thought about before, but might be applicable here. And same thing, look at PTO, vacation, sick leave, state law, company policies, and figure out whether people may use, must use, because these are all things that you're going to want to be making sure that you're appropriately running people's leave banks.
In terms of school closures, because boy, those are just all over the place now, some local and state sick leave laws are covering those kinds of closures just by virtue of the law, so you make sure that you're complying with those. And again, the CRA has been enacted, so certainly that will cover under both the paid sick leave mandate and the paid FMLA mandate does cover those school closures. You want to allow employees to use their paid leave, including sick leave, to cover those resulting absences and unemployment benefits. As we said earlier, the states have discretion to extend that to situations involving school closures, and certainly the CRA would encourage that. There are no paid family leave benefits, those insurance benefits I was talking about earlier. That's not going to apply to a school closure. Again, consider paying leave if possible. Some employers have called me and asked, can we allow our employees to bring their kids to work so that they can come to work? And boy, I would really advise you to avoid that. The liability issues are mind-boggling in terms of if the child gets injured at work. If you hire a babysitter to watch a bunch of children, you may be running a child care. That may be subject to some licensing requirements. That's not a great idea. And in addition, that seems contrary to the whole purpose of the school closure, which is to minimize contact with other people. I want to talk about requests to stay home, and people who are not because of any underlying condition, they just are afraid of contracting COVID through exposure. Can you insist that employees report to work? I'm going to let Mark talk about refusals to work in a moment. But consider allowing them to telecommute where it's possible, allow them to take leave, paid or unpaid, if it's appropriate for them to stay home. And I think, just given sort of the recommendations of the government for people maximizing their staying at home and avoiding leaving the home, we want to be considerate about these things. FMLA would not cover that. They would not be entitled for insurance benefits just because they don't want to come into work. And you can actually require employees to stay home if they say that the reason they're wanting to stay home is to avoid contact, and then you find out that they've actually gone out to Disney World or the beach. That is seriously problematic.
Fiona, I know we're running out of time momentarily, but I just want to address this one point because I think it's come up a lot. You have a workplace where you've got no known outbreaks, no employees that have tested positive. You're practicing social distancing. You have every reason to think that it's as safe can be at this point, and you have employees that they can't perform their job telecommuting, and that person says to you, again, generalized fear, I can't come to work. Can you make him or her come to work, and if they still refuse, can you fire them?
Well, I think you're actually going to get into when is it legitimate to refuse to come to work, and there has to be a reasonable belief that harm will occur under OSHA. And that that has been complained to the employer. The employer has not taken any action, and there's not enough time to have OSHA come in and do an investigation. I mean, that's basically the standard. So if somebody is really being unreasonable about it, and under those circumstances, you can, in fact, take a disciplinary action or, fire somebody for refusing to come to work under those circumstances, or insist that they do come to work. We've already talked about requests to stay at home with regard to people who have underlying health conditions and age. So I want to move on to furloughs, layoffs, and closures. That is coming up a lot. There is no business. We need to close down. What do? You can allow employees to use their PTO or vacation to cover part of that time. Sick leave laws are, likely some of them in some cases do cover workplace closures that are ordered. Unemployment insurance benefits are likely going to be available. Predictive scheduling laws might apply, so that's just something to keep in mind. There are some state laws that require show-up pay, or if you change somebody's schedule, although many of them do have exemptions for these unexpected emergency conditions. So that's something that you just need to check to see if that applies to you. If you do end up terminating the workforce, shutting down entirely, or even shutting down temporarily, you may have final paycheck requirements. Some state laws require you to pay on the last day of work. Others allow you to wait until the end of the payroll period. You may trigger WARN Act requirements. So there's a federal law that requires a certain amount of notice if you know that you're going to need to close down and you meet certain other qualifying criteria. So if you're certainly a larger employer or you're laying off your entire workforce, that's something to keep in mind and that you'll need to check with counsel about to make sure that you are in compliance with. States have some different WARN Act requirements if they have their own WARN laws, so you want to make sure that you're complying with any required state laws. And also COBRA may kick in with regard to a reduction in hours or termination of hours with regard to the continuation of healthcare benefits. So make sure that you are complying with any COBRA requirements.
Okay, bargaining obligations. So everyone out there in the audience who has a bargaining relationship with a union, raise your hand. I don't see anybody.
You're funny.
Okay, so if you have a collective bargaining relationship with a union, you're going to, at this point, need to look at that collective bargaining agreement. You're going to have to look at clauses that you're probably used to looking at if you're one of the people within your company who is responsible for working with the union or enforcing or operating under the contract. Look at your management rights clause. Look at provisions that relate to things like leave, telework, layoffs. I mean, you're going to want to see what's in that contract that may have a bearing on any of the actions you may need to take here. So again, we've talked a lot throughout this webinar about things that your company may be doing, whether it's layoffs, whether it's furloughs, whether it's dealing with requests not to work, sick leave, whatever. There are a number of provisions within the CBA that likely have some application, and obviously you need to comply with your CBA in those respects. There are some areas where you might not have specific language in the contract that deals with a particular issue. Not all contracts lay out completely how you're going to do a layoff, for example. So in those instances where your contract is silent, you would normally be required to provide the union notice and an opportunity to bargain as to something that you're going to do. Or maybe you're going to change the way you administer leave, for example. You might even be obviously willing to be more liberal than you had in the past. But because of the bargaining relationship, if you're going to alter a term or condition of employment, and the leave policy would be a term or condition of employment, you have this obligation to notify, talk to the union, give them a chance to weigh in on what you're going to do, and maybe you'll reach an understanding as to how you're going to apply something, maybe you won't, and that's beyond the purview of this presentation to talk about how that plays out. The point is you at least have to give them a chance to talk about it and hear what they have to say about it. Keep in mind that, and this is something that obviously does not come up very often, but that we may have the ability to say that a bargaining duty is actually suspended because of certain economic exigencies that are occurring, and Fiona mentioned a lot of our clients who are suffering great downturns in business. Think about restaurants that are being closed, hotels that don't have anybody staying at them, that you may need to take incredibly expedient steps that don't frankly have time for bargaining. And again, and just thinking about the kind of things that you may have to bargain with your union over that would relate to what's going on in the workplace because of the COVID pandemic, we've got them there on the slide. As far as time off related to testing, payment, for those times, whether or not you're going to have to change your shifts. Fiona talked earlier today about basically job sharing, staggered work times. All those things in the union setting would likely, contract could very easily have specific language about the shifts and when people are allowed to work, and normally you wouldn't be able to deviate from that. So those are things that are important. And then in let's say a factory setting, for example, you might have very specific job grades where people are not allowed to work in other areas, other job grades within the plant or the facility, or there's prohibitions on management performing quote unquote, bargaining unit work. These are all things that may have to be adjusted if you are reducing your workforce, getting laying off non-essential personnel, what have you. Other issues that would likely come up would be any changes to your attendance and leave rules. As I said, you might even be making them more favorable for your employees, but you still have an obligation to bargain with the union over a change in a term like that. What you're going to do about salary continuation. Once more, I'm talking about things where you may be doing things that advantage your workforce, but if you have a bargaining relationship, you're not allowed to just raise their wages or pay them money for the heck of it. So these are things that you've got to talk about with the union in most cases and try to reach an understanding. Even things like workplace safety. I have been involved in the last week in 2 separate negotiations with clients who have unionized workplaces, and we have spent a lot of time in those sessions talking about what those employers are doing to try to safeguard the safety of the workforce. And as I said before, we're all kind of learning at the same time with the help of the CDC as to what we need to do to try to make the workplace as safe as possible. But these are things that the union has a right to bargain with us about. I said this at the outset, but I do want to emphasize this, that normally you're going to have to comply with your existing provisions, and you can see there on the slide a number of standard provisions that you would expect to see in a contract. You may be looking to modify a number of those things, even things like shutdowns. Maybe the contract requires a certain amount of notice or procedure when you're going to have a layoff or a shutdown, which may not be feasible or possible here when, for example, you're at a restaurant, you've been ordered closed by the government. So those are things to look at. We talked about this before with Fiona's presentation about the employee refusal to work. The point I want to make here, I know we've got it spelled out more clearly on a later slide, but this concept of what we call protected concerted activity. So that, as I said, if you don't have a union in your workplace, you might think, well, this is all pretty interesting what Mark is talking about, but it doesn't apply to me. The reality is that under the National Labor Relations Act, there is protection for employees, even in a non-union setting, for something that occurs when they are engaged in what's called PCA, or protected concerted activity, which essentially means that multiple employees come together to share a common concern, usually about workplace safety. That's a good example. Or one employee says he or she is speaking on behalf of their fellow employees, and they'll come to the manager, boss, supervisor, and say, there's an unsafe working area over there, and we need you to do something about it because someone's going to get killed. And in some instances, an employer may feel like the person coming forward is a rabble-rouser, a troublemaker. They want to deal with him or her, and they might say, leave me alone, shut the heck up. If you talk to me again about this, you're fired. And again, under the Labor Act, if an employee is coming on behalf of a group, so concerted means more than one person. And if they're coming to the company on behalf of 2 or more people, and they are speaking on behalf of a term or condition of employment, workplace safety would be one of them, that is protected speech. And if in this instance the employee said, we don't think you're complying with CDC guidelines, we're afraid you're doing ABC when you should be doing XYZ. And it's more than just a polite conversation. It might get quite heated, or employees might refuse to work unless you fix it. So in those instances, you've got to be very careful about the fact that even in the absence of a bargaining relationship, you may have employees engaging in this PCA, and while you can obviously talk to them and try to resolve the issue, some employers in the past have decided that they didn't want to deal with this and have literally disciplined or terminated the person who had the nerve to bring this up on behalf of a group of employees. So be mindful of the fact that you may still have obligations under the Labor Act having nothing to do with a union because you don't have a union. So that's most likely to happen in this setting with some type of refusal to work or complaint about workplace safety. Also keep in mind that under OSHA, people may have a right to refuse to work if certain conditions are met. We've got a slide on that. You can read that at your leisure, but there it is. Thank you, Fiona. So realize, of course, that you may have a protection under OSHA in terms of refusing to work. And if we go to the next slide, we talk about whistleblower protections. And again, most people are probably familiar with that concept, but an OSHA violation, state law violation that would be the predicate for an employee refusing to work may actually leave aside the protected concerted activity. You may wind up essentially obligating yourself to deal with some type of whistleblower claim, which could be quite timely and expensive to address. Fiona?
Yes. So the last few slides really have to do with developing a COVID response plan and illness policies, written policies. Those are all covered in great detail in the CDC guidance that we link to at the end of the presentation. So in the interest of time, I would refer you to those that CDC guidance. We do have a whole list of the government-related guidance that has been issued. So, please take a look at that for further questions. And, of course, you can always email with questions to us. If we are your attorneys, we are happy to answer them. If we are not your attorneys, we may not necessarily be able to provide legal advice unless you want to retain us, but you should certainly reach out to your own attorneys in any case. And with that, I'm going to wrap this up and say thank you very much for joining us on this whirlwind tour of the issues associated with the COVID-19 virus.
Thanks again, Mark and Fiona, for that great webinar. If you are looking for more coronavirus info, you can go to hrsimple.com/blog or hrsimple.com/events. For watching this recording, we wanted to extend a 10% off coupon for all HR Simple products. You can use code webinar10 and use them on up-to-date employment law manuals written by lawyers like Mark and Fiona. We are here to help you with any HR needs you have. Again, we just wanted to thank everyone again for tuning in to this recording, and thank you for your patience today. If you do have any questions, please feel free to email me at anna@hrsimple.com, should be up on the screen, and I will forward those to Mark and Fiona. Have a great day, everyone. Thank you so much.